May it please the court, I'm defendant respondent Stephen Jacobs. I want to pick up on Your Honor's question right there. There is a great deal of evidence in the record that the relationship was extraordinarily hostile for a whole host of reasons at the time that his client signed the release.
You say this like it benefits you.
Well,
And what I want to know is, since when is it appropriate for an attorney in a fiduciary relationship to lie to his partner?
Your Honor.
Answer my question.
Of course, Your Honor. It's not appropriate. This was an extraordinary.
And there's no question that that is precisely what you did.
Yes, Your Honor.
Okay.
Understood, Your Honor. It is. You're correct that it is inappropriate to lie. Although I would dispute that I had any fiduciary duties to Mr. Jones as an initial matter. There's no.
From the inception of this arrangement, you had no fiduciary relationship with this person?
Well, I don't think there's anything.
You take $82,000 of his money to file bets, and there's no fiduciary relationship?
Maybe at a certain point there was.
At what point?
If the record were exactly as he said.
No, I'm asking you. You're part of the record. So at what point did you have a fiduciary responsibility?
Yes, Your Honor. If Mr. Jones had given me money to do something in particular with it, then yes, I agree there would be fiduciary obligations. Although the relationship he alleges is akin to a stockbroker relationship, and I believe there's law in this department.
You're not a stockbroker.
Well,
you're not a licensed stockbroker, so that doesn't apply. Please.
Okay. But I would like to just add that the Centro and the law in this department since Centro are very clear that you can still release, even if there are fiduciary obligations, they can be released so long as the relationship is not one of unquestioning trust, because without that, the settlement of disputes would be impossible.
But you do not dispute that you told Mr. Jones, please sign the release, and as a condition for signing the release, no, you can trust me that I will be filing a complaint with the Gaming Commission so that we can get that $200,000 I believe I owe you. Yes or no?
No, Your Honor. That is not.
I thought the threat was that either you sign this release or I will withdraw the complaint that I filed with the commission, and you'll never see that money.
Well, that's what he claims the threat was. The actual text messages of that day are extremely different than what he presented. But I agree, Your Honor, that is what the threat that he puts in his complaint.
Mm-hmm.
But I think the law is clear.
But that was an empty threat because you had already withdrawn the pretend complaint.
Yes, Your Honor.
So are you arguing that as a matter of public policy that this court should condone a release, right, for which was obtained because you lied to the person in order to get them to sign that release?
Well, again, that's what he contends. So yes, Your Honor.
Okay.
But I would
he contends it, or is that not what happened? Right? Because a part of getting the release, right, the way in which you obtained the release was by telling him that you had filed the complaint. But the record reflects that you had already retracted that complaint.
To answer Your Honor's specific question, Centro Empresarial, the Court of Appeals held just that. In that case, a party presented a totally fraudulent balance sheet that the other side relied on to sign a release. And it went to the Court of Appeals, and the Court of Appeals said, well, the real issue is you didn't realize the value of the claims you were giving up. And the reason, the policy behind this rule of the separate fraud rule is that otherwise any sort of fraud claim could never be settled with finality. So that's reason number one. And if you may indulge me, I'd like to give you the second reason in this department why releases are upheld under these circumstances. And again, there's scores of case law referenced in my brief that says when there's language in the release that says, I didn't rely on any representations outside of the release, the party claiming fraudulent inducement is forbade from claiming justifiable reliance, which is an element of fraudulent inducement.
All right, thank you.